Good morning. This April 2nd meeting of the Senate Finance Committee will come to order. We have two bills on the agenda, and I want to apologize because I had some miscommunications with Senator Rest, and she's not going to be available till 9:30. So if Senator Pappas's bill goes quickly, we will recess until about 9:30, so for Senator Rest to get here. My apologies for that, because we could have started later if I had known that. We're going to start with Senate File 1581, Senator Pappas, the Capital Mall Design Framework Implementation Appropriation. Welcome to the other side of the table.
Thank you, Mr. Chairman and members. So the Capital Area Architectural Board did an extensive outreach campaign to discuss and with people and communities all over the state about what should be done in the Capitol Mall. And one of the things that came forward is that it's not very comfortable in the mall because there's not enough shade. So trees and benches was mentioned as being really important, as well as wayfinding signs, that people who are coming from rural Minnesota, they can't figure out where to go, where everything is, where to park. So that's part of what is going on. And if you noticed, I think there's 188 trees have already been planted in the Capitol Mall. And then the first part of work on the commemorative circle, which will be a tribal flag plaza. But what happened is, and I have to blame the other body, is if you look on page 2 of the bill, they put in a really early deadline of December 31st, 2024. And admin just couldn't get everything out the door. You know, we have supply chain issues, obviously, buying the trees, getting the invoices and everything just didn't happen in time. So it's simply, we want to extend the deadline to June 30th, 2026. And that will especially help with the planning for the wayfaring signs, because that really takes time to do and time to get, to figure it out and, you know, do all the design work for that. So there's about 1.9 million left in the fund, and we just want to extend the deadline so that admin can finish the work and we don't have like this half-done commemorative plaza on the Capitol Mall.
Thank you, Senator Pappas. Before we take questions, perhaps Mr. Nauman wants to explain the
So, Mr. Chair and members, this is the first time that this committee, after approving or reviewing the budget rules, has confronted an extension of the availability of a resource. And Senator Pappas, my information is that at the date of when the cancellation would have happened, there's $1.74 million available. So that's a slight amendment to where the information that you put on the record, we just got that information yesterday. Okay. So I think that's the amount that's available. But relative to the budget rules, we have a new process for extending the availability of an appropriation in this manner. And tracking documents are now required to identify the amount that otherwise would have canceled. So in this case, we would show on tracking documents a negative 1.74 and then a positive 1.74 to demonstrate that we are extending the availability in this legislation of that number. So members would see that in our tracking documents. If this bill truly does travel on its own, in some respects it will show up on a global tracking sheet and will be a little bit hidden, but I want to fully get on the record for everyone that that's the amount that's available with this action. It would be available for alternative use or for this purpose, and that's how we will show it.
Are there questions from the committee? Senator Pratt.
Thank you, Mr. Chair. And Mr. Nauman, I'm not seeing a tracking sheet, so I'm questioning where does, so the 1.74 million actually canceled at the end of December, and we have to reappropriate effectively, and where do we see that?
So, Mr. Chair and Senator Pratt, I realize that I didn't cover everything. My apologies for this. Let me take one crack at where I think you might be going, and then if I miss the mark, you can. So Because the bill was drafted with a cancellation date at the end of December 31st, or on December 31st, 2024. That's a little bit out of cycle. Usually dollars are canceled at the end of a fiscal year or at the end of a biennium. Consequently, it was not picked up in the February forecast there is no marker in the forecast assuming that these dollars are in fact gone. So as a result, that money is still available relative to the forecast. Certainly legally it has been canceled. And my expectation is that but for this bill, it would be picked up at the end of session in our tracking and MMB's tracking. So I think that as a result of the fact that it's still in the forecast, this bill relative to the committee nets to zero.
Senator Pratt.
Thank you, Mr. Chair, and thank you, Mr. Nauman. And it's interesting that we're talking about the legal definition versus the forecast definition. And I would ask, does the bill conform in its current language with our budget rules? And then I'll have one more thought, Mr. Chair.
Mr. Chair and Senator Pratt, yes, it does.
Mr. Chair?
Go ahead.
Mr. Chair, I think it's important for us to look at this from the legal standpoint, not necessarily the budgetary standpoint. The budgetary standpoint might influence what the fiscal note says, but legally, those monies canceled and they are unavailable to this commission and at this point in time. And it should look like a new appropriation, and we should have that budget tracking sheet. Since we're going to be going into recess anyway, I'm wondering if there's, and to Mr. Nauman, if this conforms to our current budget rules, do we need to have any amendments at all to clarify what's happening?
Mr. Nauman.
So, Mr. Chair and Senator Pratt, certainly it is an option for any member of this committee to make amendments to clarify more that you feel is necessary. So I wouldn't want to put that on. I wouldn't want to answer definitively. If that's what your preference is, we can certainly figure that out. Maybe it's worth having me step through what I was imagining the tracking for this to be, and then describe some of the shortcomings of it. So in fairness and no disrespect to Senator Pappas's bill, it's a relatively small bill, and because this bill is being contemplated as a bill that would travel on its own, the global tracking sheet that I maintain on my computer would bundle this as part of an other bill. As a consequence, because it nets to zero, you would look at it and you'd say, well, there's nothing there. If there's nothing else happening, it would just net to zero. That said, if this is a material point, I can figure out how to adjust the bill tracking so that on my spreadsheet it shows the negative of the amount that would otherwise have canceled under the new budget rules, as well as the reappropriation. The risk, of course, is that if we establish that precedent on the global tracking spreadsheet, we're going to get many, many, many more pages on a document that's already relatively large. And I worry a little bit, sorry, I know this is in the weeds, but a little bit about the utility of making that sort of tracking reference. However, we can certainly try to figure out something if that's the will of the committee.
Any further discussion?
Mr. Chairman, I would just move that Senate File 1581 be recommended to pass and sent to the floor.
Is there further discussion on that motion? If not, all those in favor say aye.
Aye.
Opposed? Motion prevails.
Thank you.
And as I indicated earlier, due to my mix-up in communications, Senator Rest is not available to be here until 9:30. And so I will suggest that we recess to the call of the chair at about 9:30. But if people can stay near their phones or emails, we can let people know if she's available before that. With that, this meeting is in recess. This meeting of the Senate Finance Committee will come back to order. We have one bill remaining on the agenda, Senate File 447. Senator Rest, welcome to the Finance Committee.
Thank you, Mr. Chairman. May I begin? Yeah. Thank you. Mr. Chairman and members, I'm here this morning to present Senate File 447. This is a proposal, a bill that was brought to my attention by AARP, and since that time has become their number one priority for this legislative session. The proposal will establish a consumer restitution account limited to no more than $1 million in any given year. Some years it probably would be nothing. Some years maybe more than that. It is designed to help those who have been defrauded as individuals for whom there is no opportunity, even after a conviction, for there to be any specific restitution like there is in some cases. And so this account is established in order to set up a system in order for those particular victims to regain some of their financial resources. It has gotten a lot of help. It's set up through the Attorney General's office, but I've worked with members to do a couple of things. In particular, in your packets, the A11 amendment, which I hope will be offered, that I worked with Senator Coran, who is one of my co-authors, to really focus a bit more on transparency in this process through the Attorney General's office. And then the A13 amendment, which was suggested to me by Senator Marty. I support both of these amendments and would hope that the committee would act on them favorably.
Thank you, Senator Rest. Before we go into amendments and stuff, I wonder if Mr. Nauman wants to go through the fiscal note.
So, Mr. Chair and members, Senator Rest has identified some of this already, but the proposal in the bill is to take a revenue source that is currently deposited into the general fund and redirect 50% of that revenue into a special account that is established by the bill with a cap of $1 million, I believe $1 million a year. And the revenue source is essentially revenue that is undistributed resources that would otherwise have gone to victims, to put it loosely. And Senator Rest can correct me if I get any of this wrong. Because that revenue source is lumpy, that's an important fiscal term, it's not a predictable revenue source. There isn't an assumed resource in the forecast against which a measurement could be made of the loss. I anticipate if this bill makes its way to the tax committee, there'll be more discussion about that point. But at this point, there is no value in the forecast. What I can say is that if this bill were law, resources that otherwise unforecasted resources that would have gone completely to the general fund would be then with some stipulations, be 50-50 split between the general fund and this new account.
Questions from the, or should we deal with the amendments first, or do you want to deal with, Senator Rest, do you have a preference, questions, or?
I think the amendments first, so then the questions can be directed to the bill as complete at this point.
Senator Draham, go ahead.
I'm sorry, Chair, and thank you, Senator Rest. I love the concept, what you're trying to do here, but my question, I think fiscal, do we have an idea, over the last 5 years or 10 years, how many dollars we're talking about, just so we have an idea what we're taking away from the general fund in these economic conditions?
Well, Mr. Chairman, it can't ever be more than $1 million in any fiscal year. It's limited to that. We put that amendment on in the first hearing, so that it would not be, well, the original bill had it being 50% of any dollars that were put into, that were gotten because of convictions of fraud that did not have an individual person or entity associated with the fraud as the victim. And we've heard any number of testimony to that effect. And in the first hearing, it was clear that there had to be some fiscal limitations. We set the amount at $1 million, and again, at some point, so over 5 years, the maximum amount that would ever be going out would be $1 million.
Thank you.
Okay, we want to deal with the
year.
amendments. Senator Pratt, did you want to offer the A11?
Thank you, Mr. Chair. I'll offer the 11 amendment.
And Senator Rest or Senator Pratt, you want to explain anything about it, or just?
Mr. Chair, it's my understanding that the Attorney General has been unwilling to be transparent in some of their policies and procedures. And if I recall, Senator Rest, you probably know this better than I do, there was a Supreme Court case that effectively stood behind the Attorney General. So this would reclassify that information so that it is available to the legislature. Is that a fair summary?
Mr. Chairman, Senator Pratt, yes, I believe that is what this amendment accomplishes in language that was suggested, well, it's been suggested by more than one member, but this final language is suggested by one of my co-authors, Senator Curran, and I support it.
Senator Pappas.
Mr. Chairman, usually data privacy language is reviewed by the Judiciary Committee, and I know Senator Rest has already gone through the Judiciary Committee. So I don't know if this procedurally might send you back to Judiciary to have it reviewed, or maybe some discussions need to be had with Senator Limmer and Senator Latz.
Mr. Chairman,
Senator Rest.
I have not heard anything from Senator Latz about wanting this bill, if changes were made, to be returned to the Judiciary Committee, and I certainly would. I guess the motion today, I would hope, would be to send it to taxes. If it's in taxes and they want to see it again, I'm happy to send it back to them.
And you might want to have a conversation with Senator Latz on that.
I certainly will do that, Mr. Chairman.
Further discussion on the A11 amendment? If not, all those in favor say aye. Aye. Opposed? Motion prevails. And I'll ask if Senator Friends would offer the A13 amendment. I was just suggesting this and talked with Senator Rest about it, that given the fact that there's a cap of $1 million in the fund in any year and maybe less than that, and we don't know how many claims there, eligible consumers there may be. I see her bill has it, in subdivision 5 has it, that if there's backlog, the earliest claims get paid first, but if the Attorney General's office sees, hey, we're falling way behind in 5-year or 6-year waiting list or something, Attorney General could request the legislature recommend some sort of formula for prorating or capping them. So, and Senator Rest, I believe you think that's helpful. It's not a big deal, but I think it might be helpful. And
I think it's a very important clarification, Mr. Chairman, and I appreciate your offering, or you having it drafted, and that it would be offered today.
Senator Friends moves the 813 amendments. Is there any discussion on that? Senator Pratt, then Senator Jasinski.
Thank you, Mr. Chair. I was wondering if Ms. Stengel could kind of walk through the amendment and what the practical impact would be, because as I understand the bill, the Attorney General sets a lot of these policies and probably already has the authority to set the limits that an individual claimant can obtain, and I just want to understand what the practical change is.
Senator Combs.
Mr. Chair and Senator Pratt, I see my colleague, Ms. Severson, in the audience, and I think she'd be better equipped to talk about this.
Ms. Severson, welcome to the Finance Committee.
Thank you, Mr. Chair, members. Can I just clarify which amendment we're speaking about? Yes, so the A13 amendment makes a change to the distribution in subdivision 5, which so it states that the Attorney General, if there's a projection made by the Attorney General that there will be ongoing issues with having enough funds to distribute, the Attorney General then may recommend to the legislature that they should set a formula for prorating the distribution or capping payments in order to ensure that more eligible consumers receive payments. So it's permissive language that the Attorney General may be able to do this if they project that there'll be an issue with distributing funds to enough eligible consumers on an ongoing basis.
Senator Pratt.
Thank you, Mr. Chair. Well, I guess my question is that we give the Attorney General, I'm trying to find the language here in the bill, the ability to establish whether something is too small or we give them a lot of latitude already. Don't they already have the latitude then to, what formula will the legislature be contemplating, and won't the Attorney General already have the authority under all the other permissions to establish any sort of cap on future claims?
Ms. Severson.
Mr. Chair, Senator Pratt, yes, I think the current language in the amendment does kind of leave that discretion up to the Attorney General to determine what that formula would be. It's not clear what that formula would look like at this time. I'm not sure if there's anyone from the Attorney General here that can speak to what that prorated basis would look like or what that formula would be, or if they've done something like that. But I'm not sure what that formula would be.
Mr. Chairman, the Deputy Attorney General Whitney, I believe, is here, but I would also direct your attention, Senator Pratt, as to where that language would be inserted, and that is on page 3, where the, which is what constitutes the consumer protection restitution account, and then starting then in there in section 2, the creation of it, and then the definitions. Subdivision 3 talks about that 50% of all the money recovered would go into the account, and then starting at lines 3.11, subdivision 4, permissible use of the account, including a limitation on any kind of administrative costs. And then subdivision 5, distributions to eligible consumers. And then that's following that paragraph, 318 to 324 is where the A13 is inserted. So it's, I think it's from Senator Marty's concerns expressed to me previously that is a manner of maybe increasing the number of eligible recipients based on the money that's available and who's in line for it, and proportionate amounts. So I'm hoping that that adds both to the discretion, but also the limits of the Attorney General's authority in this regard.
And Senator Pratt, on that note, basically in the bill, the Attorney General is to distribute the money in the fund to all of the eligible consumers, and presumably if some people have $2,000 claims and supposing somebody has a $100,000 claim, that they would be paying them out. And as you see at the lines 23 and 24, that if there is a shortage of money, they pay it first to the oldest claims. And the question is, if there's more than, if they're getting a backlog and it grows as a backlog, the Attorney General, all this language does is require the Attorney General to make recommendations to the Legislature. The Attorney General has no authority to set what the prorating or capping would be. They would just be asking the Legislature for authority to do something which the Legislature would determine.
And Mr. Chairman, I would also point out that in the A11 amendment, there, in the names of transparency, there, even though no names are associated with the amounts that are paid out, the amounts themselves are part of the Attorney General's report.
Further discussion. Senator Jasinski, no.
Mr. Chair.
Senator Howell.
Thank you, Mr. Chair. Can you or someone explain to me how that amendment will work with the lines from 4.1 to 4.13 and that discretion that the Attorney General has? How do those two either complement or conflict with one another?
Mr. Chairman, I would leave that to counsel. I don't believe they do contradict, but I'll leave it to them or to the Attorney General.
Ms. Severson, you want?
One moment. Thank you, Mr. Chair. Senator Howe, so those lines fall under subdivision 6, which is the subdivision that leaves it up to the Attorney General to determine whether distribution to eligible consumers is unreasonable for whatever reason. And so that's what that language in paragraph B determines, that it's unreasonable when the judgment, and then it kind of explains that there. I don't believe it contradicts with the language in the A13 amendment. It's kind of addressing two separate issues there.
Senator Howell.
Thank you, Mr. Chair. And so where I came into it is actually on 4.7, where it talks about the number of likely consumers and the amount of the likely unpaid consumer enforcement. It looks to me like, isn't that similar to what we're doing here? It's the amount of what we have, the number of folks that need the money, and then the amount that we have isn't enough to give to everyone, so it gets to be so small? Or isn't that similar?
Yeah, Mr. Chairman, I think that what the language in 4.7 is you have to read the whole of subdivision 6. And if there is an amount that's owed that's like $25, that the Attorney General's office or the account administrator is not compelled to expend unreasonable effort to try and find that person to give the restitution as well. And it's not only that the culprit, the fraudster, may not be found for any individual criminal conviction, but it's also the case that perhaps the victim has, in a sense, within the meaning of trying to find somebody, no longer exists. They may have died, they have been moved out of state, any number of circumstances. And if the money, under any reasonable consideration, which I think really is spelled out what that means in subdivision 6, which is different from subdivision 5, as she just pointed out, that there is kind of like relief from not having the account administrator pursue that in a way that would seem to any reasonable person to be absurd.
Mr. Howe?
Thank you, Mr. Chair. I guess when I look at it, I think the Attorney General has that discretion already. I don't know if we need the amendment, but it looks to me like there's a lot of discretion that the Attorney General already has in determining, and of course, this is more for the bill rather than the amendment, I guess, but I'm concerned with the latitude we're giving him.
Ms. Severson, I think most of the committee now knows you and know you work for Senate Council and Research, but could you briefly identify yourself for the record?
Yes, Mr. Chair, my name is Olivia Severson, Senate Counsel. I cover Commerce Committee and Energy Committee.
Thank you. Is there a further discussion on the A13 amendment Senator Friends offers? If not, all those in favor say aye. Aye. Opposed? Motion prevails. On the bill, further discussion. Senator Pratt.
Thank you, Mr. Chair, and I'd like to go back to the fiscal note for a minute if I can. And Mr. Chair, what we see is a draw from the general fund. And in fact, if you look at page 4 of the fiscal note under bill description, that the money is in fact under current law being deposited into the general fund, and that we would be taking up to 50% of that money out. The bill would redirect a portion of those general funds to the newly created Consumer Protection Restitution account, but yet we have zero cost. And while Senator Rest has talked about $1 million, right? Mm-hmm. And I think Senator Dreheim asked how much has been taken in the last few years. Well, in 2021, we received $9.2 million. In 2022, we received $3.6 million. In 2023, we only got $398,000. In 2024, we got $3.2 million. And it's, we've seen agencies make estimates on these all the time, and the fiscal notes that have come in front of this committee have been either really, really wrong or incomplete. And I would like someone from MMB to come up and explain what the fiscal impact is. It's not much, as Senator Rest said, we're probably talking $1 million, but it's not nothing. And I think that it needs to be documented on what our assumptions are going to be, how much is going to be staying in the general fund and how much is going to be pulled out, because I do have questions about the, how much is pulled out as well, Senator Rest. But I'd like to start with that, Mr. Chair.
Well, Mr. Chairman, I will go back over that again. We, even in the first committee meeting, were very aware that it was an open-ended amount by just saying 50% of any restitution dollars would be reserved for this purpose. And so we put in the amendment to limit it to $1 million. It can actually be less than that. It can be $500,000. Or $250,000 or $2 million. I mean, the $1 million was certainly an arbitrary amount, and as you just recall, repeated to us, 50% of those dollars would seldom get to, or not seldom, would unpredictably get to a total of $1 million. And some, and maybe some years, again, it's not impossible to consider that there were no dollars available. And I think the lowest amount you mentioned was like around $300,000. So 50% of that would be $150,000 in that given year. So it could be as much as $5 million, but over 5 years, which was the question Senator Draheim asked, but it could be far lower than that. It would just not exceed that.
Senator Brett.
I would,
And,
again, the question is on the fiscal note, Mr. Chair, not necessarily.
Yeah, Mr. Chairman, we accept the fiscal note. Generally, I don't usually deal with bills that have fiscal notes, but only revenue estimates. But the LBO, I'm assuming, contacted MMB to come up with this, and you can see, not to get into a different jurisdiction, but the recipients of these restitution amounts, that income, just as we're doing in some other areas with coerced debt, would not be taxable in Minnesota, independent of whether it's taxable by the federal government. And also, it would not be considered a source of income in determining the property tax refund. That is going to bring about a revenue estimate, and we may have to actually, when it gets to taxes, which is where we can't get a revenue estimate until then, where we may have to put that non-taxable income back into a source of income in determining your property tax refund. I would balk heavily in saying that the restitution amount, no matter what it is, should be considered taxable income.
Senator Pratt.
Thank you, Mr. Chair, and I'm just wondering if there's anybody from MMB that can talk to my concern, because just because it's a stream of income, just because those resources are, to use that very technical term, lumpy, that doesn't mean we can't somehow estimate or presume, let's say, over a period of time, what that's been and can be expected, right? In three of these 4 years, we would have exceeded the 1 million. We would have hit the $1 million cap, and closer to 200,000 in, would have been redirected in the 1 year.
Mr. Chairman, I couldn't agree more, and I don't have that I personally don't have that information.
That's why I'm asking MMB,
Yeah,
Senator Rest.
MMB hasn't given it. Somehow you've obtained the information for 4 years. It would be of interest to me, and maybe to you all as well, to look back maybe 10 years on what has happened with restitution to period, but keeping in mind that these are very special victims. These are victims of people who were convicted of fraud, and then had no resources. They had spent it all, and they, quite frankly, one of them, in one stop shop, they had all paid. And after being convicted, to Hawaii. These are the people we are trying to help. And we've heard testimony about how by being scammed on a phone call, and maybe this has happened to some of you as well, that someone posing as your nephew or a long-lost friend is in trouble, and they need $5,000 to post bail on some arrest that had been made for them. They pay the money. They are humiliated at the loss at that loss, and when they discover the fraud, and there's no way of recovering from the initial fraud that was committed against them. On one occasion, the courier who was picking up the cash, so usually in cash, he was arrested, but the person who he was the agent for was nowhere to be found. And so an initial outpouring of $20,000 for a nephew, that was totally lost, and it represented, it's not only older people that are victims, there are young people who are victims too, but it has the, unfortunately, older people generally have more discretionary income put in their savings, and are more vulnerable to, it's like rob a bank, well, because that's where the money is the famous quote, and that's true with older people as well. Right now, I keep getting all these messages that my MenPass account is in arrears. I mean, come on, and that I better pay this, or I'm going to get arrested. I have this information, Mr. Chairman, Senator Pratt, from MMB, but I don't think it makes this bill less of a compelling proposal and policy to adopt by the Minnesota Legislature.
Mr. Dow from MMB, should I have him come up, Senator President?
Yes, Mr. Chair, and Senator Rest, as you know, I spent nearly 10 years in fraud and fraud prevention.
Yes.
I'm not questioning that. What I'm questioning is just as you would be unwilling to use an incomplete revenue note to pass a tax bill, I think it's
possible.
Exactly, and yet we continue to see incomplete and irrational fiscal notes in front of this committee, and I don't think it should be tolerated.
Well, Mr. Chairman, actually, I take that back. It certainly is possible. We get revenue estimates all the time that say unknown, unknown, because that kind of information is not available. Any of you who have had a bill before the tax committee, you look at the words unknown and you say, oh, thank God. And if it has parens around it, it means it's unknown, but it's for the benefit of the taxpayer. If it's not, it means more money for the state. So I anticipate that the revenue estimate is going to have unknown, other than the property tax refund portion of it, unknown with parens. And whether we have before us right now that information, I think this is a worthy effort. Mr. Chairman, Senator Pratt, and I hope you'll support it.
Mr. Dahl, welcome to the Finance Committee. Can you respond to the concern raised by Senator Pratt?
Thank you, Mr. Chair. For the record, Brian Dahl with Minnesota Management and Budget. I will speak first in generalities about how we approach revenues like this in our forecast, and then touch a little bit on the bill in question here. First, when we forecast revenues, we put them into broad buckets. Those revenues that are consistent and the state collects as, such as the biggest ones, income tax, corporate taxes, and we look at past revenues and future forecasts and put that into the forecast and obviously price legislation against that forecast. With revenues, like the revenue in question today, as Mr. Nauman referred to it, they are lumpy in history, and they're difficult to forecast going forward. And we tend to have a bias in the forecast of remaining conservative, so we're not adding money to the general fund forecast that then won't materialize in the future when a settlement we're forecasting doesn't come in, because we want to make sure that we aren't supporting appropriations with revenue that we aren't certain will come into the general fund. With this revenue in particular, the data Senator Pratt cited earlier today, it was the first I've heard of that data from the AG, and I would like to ask for a little bit of time to go back and look at that and talk to the AG to understand exactly what data they have supporting that, and with the possibility that we come back with some more information on what's truly in the underlying forecast related to this particular revenue source.
Senator Pratt.
Thank you, Mr. Chair. And I would just say that the information I got came from Senate Fiscal. And if they have access to this information, I'm surprised that you don't, as the finance arm of the state.
It came from where?
Senate Fiscal.
Oh, Senate.
So, what? So we have, we do have a great team, as Senator Murphy just said. They are excellent. I expect MMB to be excellent. I expect MMB to know what's coming in and going out. I expect MMB to know that these are the amounts that would be impacted had they taken the time to ask the question. This is an incomplete fiscal note, Mr. Chair. And I get the sense that there was no attempt to do it because it might have taken a little bit of time or something. I don't know. But if we can get these numbers here in the Senate, certainly you can get these numbers, and the chief financial officer can get these numbers, and we can put together, as Senator Draheim said, some sort of averages or estimates on what those draws might be, especially if they're capped at $1 million. We would have taken out $3.2 million in those 4 years. And you're telling me that we can't estimate that in any sort of way over any period of time, take whatever reasonable time frame that you want to look at. I just find that we've had a horrible, the fiscal notes that I've seen come out of this administration have been horrible. we've missed on so many estimates along the way. And this is one. And just because it's hard doesn't mean that there's not a way to do it. I've done a lot of forecasting. I've done a lot of budgeting in my time. I spent 30 years in banking and financial services, as well as being part of the fraud team. I had to estimate fraud losses. I don't know who's going to try to steal from me. But I had a pretty good idea that I could come up with some sort of baseline estimate. I might be a little high, I might be a little low some years, but I could at least come up with some sort of estimate of what we've seen in the past. I think we should table this bill, Mr. Chair, and send it back for them to do their job.
Mr. Dow.
Thank you, Senator Pratt, Mr. Chair. I appreciate those comments, Senator Pratt, and like I said, I would like to take some time to go back and look at the data you're citing to make sure that the committee has all the information it needs.
And Senator Pratt, I think this is a question also for Legislative Budget Office in terms of that, because I mean, the role of who's responsible for putting together fiscal notes, I think it's a legitimate question and so on, but I think that MMB's role in forecasting things, I think, is a little bit different than the LBO, so I think that's another question on who should be talking about this. So, further discussion on this? If not, on the bill, or any part.
So thank you, Mr. Chair. Let's go to the bill itself. And I'm wondering if somebody from the Attorney General's office, I'm looking at lines 2.14 through 2.17. We use the term vindicate, and then we say, by providing restitution or other compensations to persons directly impacted by unlawful acts and practices that are the subject of enforcement action. And Mr. Chair, what I'm wondering is,
Could you, Senator Pratt, would you give those line numbers again in the third engrossment?
yes, Senator Rest, I'm looking at consumer enforcement public compensation lines 214 through 217.
214, okay, thank you.
And I'm curious about the word vindicate, and I'm curious as to whether there must be a collection effort made in a specific case for those victims to be compensated, or will the Attorney General compensate when no monies have been recovered?
Ms. Whitney, would you like to come forward? And please identify yourself and then you can repeat the question if need be.
Thank you, Mr. Chair, Committee. Jessica Whitney, Deputy Attorney General over the Consumer Protection Section. So Senator Pratt, can you please sort of repeat that for me?
Yes. Sorry, I missed your name again.
Jessica Whitney, Deputy Attorney General.
Thank you. Deputy AG, I'm looking at Section 2, Subdivision 1, Item E, on lines 214 through 217. I'm wondering if you can tell me what the word vindicate is intended to convey, and then could someone that, let's say there was a consumer protection action taken by the AG, but no monies were recovered, would those victims then be eligible for compensation under this fund?
To answer the second question, yes. That's the idea, is where because we have that now, cases where we pursue and there is no money, and we pursue the case usually for injunctive reasons to stop the bad actors from pursuing that, but the bad actors have declared bankruptcy, the money's been spent, it's gone. So ideally, those are the victims, in part, that would be protected by this fund. In terms of what vindicate means, I think it means make good on the public interest, that these are actions or awards that are supported by public interest, that the public interest is supported by bringing these.
Senator Pratt.
Thank you, Mr. Chair. So to use Senator Rest's example of the dentist, we take in monies collected from that dentist and the sale of his assets, and we put $1 million of those into this fund, and unnamed claimants can then, of that dentist can come in and make claims against that, against those recoveries. Is that correct?
Mr. Chairman, there were no assets, and nothing was recovered from the dentist. Those are not the people, those victims that can be identified to a specific fraudster are not the ones that we're concerned about here, because those cases where there is assets, the court decides how they are to be monetized and sent to a specific victim. And so you're not recalling the example correctly. This person just absconded, but was identified publicly as committing fraud against any number of his so-called patients.
Senator Pratt.
Thank you.
Think of another example, if you would.
Well,
Because that one's not.
you know, we'll just use Acme Coyote Supply if you don't mind. So Acme Coyote Supply has their assets sold, and they go into the general fund, and those monies are pulled out. And what I'm hearing is that people, let's say then by the dentist, if I'm going to be factually correct, can then make claims against the monies that were collected from Acme Coyote Supply.
Ms. Whitney.
Mr. Chair, Senator Pratt. So what would happen in that case is currently, I mean, let's use the dentist case. We're tracking bankruptcy, making our claim. If we get money for that, that is not right now covered under this bill. That's our existing law. We would take that money as we can and prorate it out by how many victims we have and how much ever, if we're able to recover anything. And I don't know that we're going to be able to in that case, to be quite frank with you. So what would happen then to those victims in that case, since there's nothing left in bankruptcy and we can't get it, and there's a list of creditors and we fall in that list and there's nothing, is that other cases where we've got civil penalties from corporations who've had money but have done wrongdoing, so we've gotten penalties from them, or cases where we've gotten a little bit of money, but it would have been, I mean, I've seen cases where it would have been 50 cents to the consumer, and that's not worth mailing, 10,000 people, 50 cents. So that money then goes back to the general fund. So half of that money, up to $1 million, would then go into this fund to reimburse the dental folks, to reimburse the Acme people. It wouldn't come from Acme, if you're understanding me. It would come from these other cases where there has been money.
Senator Pratt.
Thank you. So as I read the bill, the money was coming from cases where there are unnamed claimants, right?
Senator Pratt, the money is coming from cases where the consumers have already been restituted in full, because that's always the number one priority, where consumers are restituted, and we've either got, or consumers can't be restituted, like I said, because it's too small and it would cost more money to restitute them. And we've gotten in those cases, so either those cases or the cases where we have excess money because of consumer penalties, that money currently goes back to the general fund. Or we can't track down people and it doesn't go to unclaimed property because we just can't even find people, or the consumer list isn't complete. That money all goes back to the general fund. So.
Senator Pratt.
Thank you, Mr. Chair. And Senator Rest, you mentioned the $1 million cap. I'm wondering if you can talk about that and how that was determined.
Senator Rest.
Mr. Chairman, Senator Pratt, in the first committee hearing, there had been discussion before that with the folks from AARP as well as others, and that there needed to be a limit. And and in a sense, they didn't have this information that you were asking MMB about of what would be a reasonable amount. And so it seemed to them, and then I was easily convinced that $1 million was not unreasonable, even if, in this instance, arbitrary. So it could have been $4 million, it could have been $2 million, it could have been $500,000. That seemed to me and to the folks in the ARP who are supporting this legislation to be reasonable. I'm sorry if you think it's not.
Thank you, Mr. Chair. And Senator Rest, I'm not commenting whether I think it's reasonable or unreasonable. I'm just asking.
It was arbitrary, but it certainly wasn't 50 million, because that would have been very unreasonable. It would have been absurd.
We'd have had a zero fiscal note. It would have been okay. Sorry, Mr. Chair. I shouldn't do that.
Is there further discussion? If not, Senator Friends moves that Senate File 447 as amended be recommended to pass and referred to the Committee on Taxes. Any discussion? If not, all those in favor say aye. Aye. Opposed?
No.
Motion prevails.
Thank you, Mr. Chairman.
Thank you, Senator Rest. With that, just a reminder to people that I think yesterday evening, Elspeth sent out hold times for our regular finance meetings and some additional finance times over the next few weeks as we go through all the omnibus bills. Please put those holds on your calendar, and we'll be getting in touch more with which bills will be heard when. We expect to meet next week on our regular Tuesday, Wednesday, and Thursday times, as well as Friday morning to start work on the early omnibus bills. And with that, this meeting's adjourned.